or comments for the sponsor of the legislation? All right, seeing none, we're going to go out of session. Mr. Gentry, you're on the list. If you don't mind coming forward, stating your name and position for the record. And you have 4 minutes, sir.
Is this on? Okay. This bill is clothed in good intentions, but actually it's prima facie evidence of a breakdown in the legal profession and its ability to provide oversight and self-government. The bill is unnecessary and duplicative of existing rules. It's contradictory of existing rules, and it's ambiguous language.
Will you state your name, sir? State your name on the microphone, please.
My name is John Anthony Gentry. The language is ambiguous, and it invites use that is opposite to its intended purpose. It is hostile to justice and to ethical rules by punishing a party who may be a victim of fraud while holding harmless an attorney who is guilty of filing a frivolous lawsuit. How this duplicates existing rules, we already have Rule 12.02, subparagraph 6, failure to state a claim. You can get a case out with that, and judges always stay discovery pending resolution of a 12.026 motion. Rule 11.02, representations to the court. An attorney is certifying to the court that his complaint or any paper, any pleading, is not to harass, that it's not to cause delay or needlessly increase the cost of litigation, and that the claims are warranted by existing law and without frivolous argument. That is a clear representation that an attorney is making when they file a complaint in court. They are certifying that. Now, this has to be true. If an attorney is filing a frivolous suit, that attorney is guilty of malpractice or they are guilty of fraud. Because they are certifying to the court that it is based on warranted or existing law and that it's not frivolous, that's fraud on the court. And it may be fraud on the party because they're representing to their party, yeah, I can win this case, when they know that they don't have a chance in court. So it's fraud on the client to collect attorney fees from the client. Pursuant, we talk about the deterrent, and I heard Senator Dickerson talk about it in the Senate committee. He said that these sanctioning attorney fees is important deterrent. We already have that too. It's in Rule 11.03. 11.30a, if in violation of 11.02, opposing counsel can sanction after providing 21 days advance or opportunity to withdraw or amend the complaint. That's called the safe harbor provision. The purpose of our law is to deter, it is not to punish. And that is how this bill is hostile to justice. It's bent on punishing rather than applying the safe harbor rule. You got 21 days, get it out of there. Now we get down to
60 seconds, sir.
And under this rule 1103B, monetary sanctions may not be awarded against a representative party. So clearly this slap bill is in conflict with 1102 or with 1103 and 1102. And that provides in 1103 that if it is determined to harass or if it is determined frivolous, that the judge can sanction and award attorney fees. And the law firm shall be held jointly responsible. And this gets us to how there's a breakdown in the legal profession, and that's an important phrase in 11023A where it says the law firm shall be held responsible. Tennessee Supreme Court Rule 8, Rules of Professional Conduct, Rule 3.1, a lawyer shall not bring unless after reasonable inquiry the lawyer has a basis in law and fact, and that doing so is not frivolous. It's required by ethical rules of attorneys not to present frivolous lawsuits.
All right, Mr. Gentry, we're going to move on into questions. If you'll stay right there. We got any questions or comments for Mr. Gentry? Chairman Sanderson, you recognize, sir.
Thank you, Mr. Chairman. Mr. Gentry, you heard the testimony or the presentation from the sponsor of the bill, and he contends that this is a bill that we need, and you contend it's not a bill that we need. That puts us in conflict. And so how do we disseminate between what you say and what he says?
You recognize Mr. Gentry.
Well, thank you for asking that, Representative Sanderson. The next point I was going to make is the rules of professional conduct require a lawyer who knows that another lawyer has engaged in misconduct shall report them to the Board of Professional Responsibility. And the same is in Rule 10, Code of Judicial Conduct. A judge that knows of attorney misconduct shall report them to the appropriate authority. So here we have a complete breakdown. We've got an attorney filing a frivolous lawsuit. We've got opposing counsel who is failing to report them for ethical violations, as well as the judge. The whole thing has broken down. If we want to solve frivolous lawsuits, it's not through a slap bill like this. I would encourage, and I would be honored to assist in drafting a bill to properly address this problem. And to do that would be to fine and sanction the attorneys from both sides and the judge who are involved in a frivolous lawsuit that don't report that misconduct to the Judicial Oversight Agency or to the Board of Professional Responsibility. So that's the conflict, is we need to start enforcing the ethical rules and start to heal our nation of the misconduct that's happening in our courts. We don't need legislation that is duplicative and that is contradictory of existing rules.
Thank you, Mr. Gentry. Chairman Sanderson, you recognized.
Yes, and thank you for your response. Are you familiar with any lawsuits that were brought that were frivolous?
Mr. Gentry, you recognized.
I apologize, I'm hard of hearing.
Are you familiar with any lawsuits that that could be interpreted as frivolous? And are we addressing a problem that doesn't need to be addressed? Are we addressing a problem? Obviously, the Chairman Ramsey has seen a need, and so I guess I'm asking you: are you not aware of frivolous lawsuits, and are we addressing something that doesn't need to be addressed?
You recognize.
We have an incredible problem in this country with frivolous lawsuits and false, unsupported allegations. And we need to start enforcing the ethical rules to make sure that stops. Did that answer your question?
Chairman Sanderson. All right. Any other questions or comments for the witness? All right. Seeing none, we're going to go back in session. Thank you for your time, Mr. Gentry.
Thank you, Mr. Chairman.
Back in session.
Thank you, Mr. Chairman. And
You